Okay. All right, let's get started. All right. Good evening, everybody. Thank you for coming. My name is Louis Polito, the Belmar Public Library. Thank you for coming tonight to this first of three presentations by Tina James over here on disability law for families with special needs children. I want to welcome everybody watching live on the Facebook stream over there. I hope you enjoy and can hear loud and clear. Please put in the comments below if you can hear clearly and you're enjoying what you see. If you have any questions, put them in the comments as well and we can respond to them later. So, without further ado, I want to present to you Tina James.
All right, thank you everyone. And thank you, Louis, for having me out, and I appreciate the Belmar Library hosting this event. So my name is Tina James. I'm an attorney. I've been practicing for over 10 years now. I practiced litigation for a while, so I can kind of see everything that's gone wrong. The last 3 years, I've been doing the planning part of it. So tonight we're going to cover planning for your child with disabilities. Now, just gauging by the group here, child in your family, what age group are we talking?
17.
17. You said 17 as well. Okay, so some of the things that I'm going to touch upon do apply to some younger kids, and then we're going to go into that transition phase. We do have a big chunk on that between that 16 to 21 time frame, but I just want to cover some of the basics for them as well. If you have questions, save them till the end, and if you do have questions, we're going to try to ask them generally because we want to make sure we're not sharing confidential or private information with our friends at home with that. So this is what we're going to cover tonight, right? So we're going to talk about the educational entitlements. If you're planning for your child, what they're entitled to, how long they're entitled to stay in school. We're going to talk about some of those issues with COVID, having that extra year that the governor recently passed with that new legislation. We're going to go age order here, so we're going to transition into adulthood. We're going to talk about things like guardianship, whether a guardianship is appropriate. We're also going to talk about that other side of the coin. When guardianship is not appropriate, what are your other options to continue giving support to your child? Obviously, government entitlements, this becomes really important. If you're looking for services after they turn 21 through DDD, Division of Developmental Disabilities, and we need to look at things like SSI and Medicaid and how you become eligible for those types of things and why that matters. We're then going to move into estate planning, right? And we're going to talk about special needs trusts, why that's important and why we need to worry about that as mom and dad, grandma, grandpa, making sure we don't jeopardize the benefits and the plan that we put in place for our child. I'm also going to cover New Jersey ABLE accounts, right? It doesn't really fit into any of the other big categories, but I think this is really important for families to know about if they don't know about them. All right, so let's dig in and get started. So, special education. Special education falls under, there's four main categories of the law, right? So we have the IDEA, which is the Individuals with Disabilities Act. 504, which is a Civil Rights Act. It's Section 504 of the Civil Rights Act. We have the Americans with Disabilities Act. And then we also have these laws and portions of them that have been codified in New Jersey state law, right? So we have it both on the federal level and on the state level. These are the laws that apply. Now, I don't want to overwhelm you with the numbers or the statutes, so I'm just mentioning them. The reason why I mention them is because your child's entitlement to an education and to accommodations within their education comes from different places, right? So, under the IDEA, the Individuals with Disabilities in Education Act, they're entitled to a free and appropriate education, a free and appropriate public education. They're also entitled for that to be in the least restrictive environment. So let's talk about a couple of those things. What does it mean to be free? It means mom and dad, they're not paying for them to be educated. That means if they need an out-of-district placement, their sending school district is covering the cost of that placement. Appropriate means your child has been evaluated. There have been evaluations, whether it's an educational evaluation, a psych evaluation, to know what their educational needs are. Right, so we need to make sure that the plan that's put in place, the IEP, in the individual education program, matches what your child actually needs, right? So judging by the fact that your children are 17, you've been probably through this process quite a bit along the way. What a lot of people don't realize is that an IEP only applies to 13 disabilities, 13 categories of disabilities. It doesn't cover everything. So that's why sometimes you'll hear students have a 504 plan. Right, and the 504, it says you can't discriminate against a child. You need to make an accommodation with a disability, but it's not limited to 13 disabilities, right? So example is I have a 2.5-year-old who has a periodic fever disorder, right? She gets fevers during COVID. That's really kind of, welcome. So she gets fevers, during COVID. That's pretty difficult to send her to a preschool. However, we have a 504 plan. That is because she does not fit into the category of one of those 13 disabilities, right? So we have that to make accommodations for her to attend preschool. All right, so under the IDEA, you have the IEP. That IEP, and we do a whole presentation on the IEP, but parents have rights as part of the educational process. So you are entitled to be involved in that. You're entitled to have a say in what your child's education looks like. There are specific rules as to who needs to be present at an IEP meeting. You're like nodding your head like, been there, done this. Maybe it hasn't gone the way that things should have gone, and maybe they haven't. But that IEP gets reviewed annually, right? If you have a 504 plan, it does also get reviewed annually, but the law isn't as specific with how frequently that needs to get reviewed, right? So a lot of times what we'll do is we'll see school districts try to push a 504 plan instead of an IEP because they don't have that same level of requirements, that they don't need a reevaluation every 3 years. Okay. One of the other pieces is that if your child needs to, they are entitled to be in school up to the age of 21, right? Usually what happens is in between the ages of 18 and 21, the focus is on that transition to adulthood, vocational training, life skills, depending on the nature of that child's disability. So once they've reached 16, the IEP should be spelling out what that transition plan should look like, what we're looking for going forward. A lot of times it'll be pretty vague, but then it'll start to get filled in a little bit more as you get closer to that 18. Now, new legislation was passed separately. Now this is COVID related. So as a result of COVID, kids across the board, kids with a disability and without, had significant learning loss when the schools were closed, right? So there's no doubt about it, that significant learning loss. The state of New Jersey has come out and said, yes, we recognize that. We recognize that's across the board for kids to have been affected. Kids that have an IEP, that have special education, they are entitled, if they are in the class of 2021, 2022, and 2023, to ask for and have an additional year, a fifth year, I say a fifth year, but if they're entitled to stay in school till the age of 21, it would be an additional year beyond that, their entitlement, right? The key is that at the age of 21, we're going to talk a little bit about supports and services through the Division of Developmental Disabilities. The key is that they can't overlap the same types of supports and services, right? So we need to make sure that if you're getting vocational training through the school district, you're not going to be getting vocational training through DDD, right? So the state's not going to provide it to you twice. So you just need to be clear about what supports and services you are getting. So new legislation is passed. If you have an IEP coming up, most of them are in the spring, make sure you're asking the school and telling the school, I want my child to be considered for this, if you want them to. I mean, you should be talking about that transition plan, but making sure, I know a lot of schools didn't have that conversation with families this past spring because the law hadn't been passed yet. It was just passed over the summer. So now when those come up, if your child fits into that, definitely want to make sure that you bring that up to them. All right, so those are just some of the ways in terms of the education that we're gonna provide for our child. Transitioning through their life, we're getting to about the age of 18, and we're going to be thinking about whether or not they need a guardianship, right? So guardianship is hard, especially at this age. Sometimes children are still developing skills. So the standard for whether somebody needs a guardian is whether or not they can manage and govern their own affairs. And I'm going to pull that out so we can see some concrete examples of what that looks like, but that's the legal standard. And so sometimes an individual who's 18 or 19 can't manage or govern their own affairs just because they're not mature enough, right? And so we need to separate out what is not being able to manage and govern their own affairs and they need a guardian versus just not being mature enough. So some examples, the court's going to look at things when this process happens. The court's going to look at things. Hi, Sarah.
So sorry.
No problem. Glad to join us. They're going to look at things whether a person can manage and govern medical decisions, legal decisions, financial decisions, and their self-care. So let's break this down. Self-care, can they get dressed themselves, right? Now I'm gonna say right now, as parents, what we do is we put our child always in the best light possible. We always think about what they can do. We never think about what they can't do, right? And this is difficult for us because we want to see what our child, the best in them, right? That's what we do, right? When we are looking at whether they need a guardianship, when you're applying for things like services through DDD, you need to figure out what they can't do because that's where the support is needed. That's where we need to plug those holes and fill in the gap. So one of the things is, can they get dressed independently? And a lot of parents say, okay, yeah, my child can put on clothes. They can put one foot in the pant leg, the other foot in the pant leg, they can button their pants. Will they pick out seasonally appropriate clothing if you're not there? Will they remember to get dressed if you're not there? A lot of times we provide supports and we don't realize that we're providing supports. Example is, can they shower independently? So if you weren't there, would they remember to shower? Would they know how to set the water temperature? Would they wash the soap out of their hair? Right? And so these are all supports and we don't realize that those reminders are, and if they were to travel on vacation and go somewhere by themselves, could they figure out how to adjust that water temperature? And so I've had a mom say to me, yeah, my son can shower independently because I took a Sharpie and I put a black marker where he needs to turn the dial. Well, no, that black marker and that little mark is now that support, right? So that's just one example. So we look at things like, can they dress themselves? Can they take care of themselves? Can they cook meals for themselves, right? Can they brush their teeth independently? Or do they need those supports and reminders? Like I said, you might have a 19-year-old boy who doesn't want to shower, and that may be very typical, right? That might just be, hey, I'm 19, I don't want to shower, I don't want to do anything, I want to play video games today, versus looking at, does somebody need a guardian? So it's not just those types of things, we have to look at the big picture here. Let's take a look at some of those financial decisions. Could somebody be taken advantage of financially? Do they understand the value of money? We had one individual who had an Uber, the app on his phone, spent, I think it was close to $30,000 over a couple months because he did not understand, he was in his mid-20s, the value of clicking that button and having a car pick him up and drive him places, right? He was just saying, okay, I got it, I can go for a ride, I could do this. Newfound freedom, but didn't realize that there was a value or could calculate how quickly he was spending money. It was very abstract. We go to ShopRite, we go to BJ's better example. You start shopping, you throw 5 things in your cart, you know you've spent $100. You go to the checkout, if somebody said to you, you just spent $500, you're gonna be like, excuse me? What? Can we double check this? If they said to you, hey, you only spent $10, you're like, I have 5 items in here, I know they're all $20 a piece, this isn't right. We instinctively know this because we know the value of the items we're putting there. We have a ballpark of how much we should spend. An individual who can't manage and govern their own affairs isn't going to be able to do math functionally sometimes, right? They might be able to do it on paper, they might be able to do it with a calculator, but in the real world, they could be taken advantage of by somebody else, right? So that's the financial piece. I recently had a guardianship for an individual who had their gaming account hacked probably about 30 times in the last year. The reason why is he became very trusting of these online friends, and he would give out his passcode, he would give out information. So he was putting himself, his family at risk by sharing information online with strangers. He was vulnerable, he did not understand the consequences, and he couldn't manage his account that way. Medical decisions. Can that person make a medical decision? That means, can they weigh the risks and the benefits of a medical procedure? So if the doctor said to them, hey, you need your tonsils out, could they understand, well, I'm going to go under anesthesia and what those risks are versus the risk of maybe having strep throat or having a sore throat long term, and what sort of benefits they have from having the surgery versus not having the surgery? A lot of times individuals can take medication because it's part of a routine, but do they understand the benefits of that? Right, so these are all sort of the big picture things that we're looking at to decide whether or not a guardianship is appropriate. And a lot of times people think that when you have a guardianship, it takes away somebody's rights. They still have the right to marry, they still have the right to vote, they still have the ability to get their driver's license. I heard somebody mention that earlier. Somebody wanted to get their driver's license. It doesn't prohibit them from getting their driver's license. So these things still exist for them. So it's not like you're taking away everything. If they do need a guardianship, what you're doing is you're putting a person in there to protect them, to make sure that they're not taken advantage of. So there's 2 types of guardianships. court. It's of the person, which means decisions like where they live, where they go to school, what day programs they might be in, what sort of recreational activities they're involved in. Guardian of the property is if they have any assets, right? So if they have money coming in, who's going to control that, again, to make sure that they're not being taken advantage of. Two words that the court uses: plenary guardianship or limited guardianship. Plenary would mean in all areas. That, the court would say they need a guardian in all areas. So it's legal decisions, medical, financial. Versus limited guardianship, a court might say, hey, somebody can manage their educational decisions. They can manage decisions about where they live, but they don't necessarily have the ability to manage their financial decisions. So the court in New Jersey, the standard is we only want to take away the bare minimum of what's needed, right? So the court's not going in saying we want to take away, obviously it's not the court, but the court wants to make sure that the petitioner does not want to take away as too much. We want to make sure only what is needed to protect that person, right? So the limited guardianship is appropriate, then that's what the court is going to look for. Even no matter what the parent asks for, they're going to look for the most appropriate decision for that person. So the process, can't file for guardianship until the person turns 18. So I usually tell families that I work with, let's start the process about 6 months, 3 months before then. Why? Because we need to coordinate a couple of things. We want to coordinate some doctor's visits. We need to have 2 doctor's certifications saying that the person can't manage and govern their own affairs, right? Most doctors in New Jersey are familiar with the guardianship process, the form. It's a standard form that they've used before, so they're familiar with it. The other thing I tell families is we're going to apply for guardianship. We can't apply until the person turns 18. There's probably about a 6-week, maybe 8-week gap between when we submit the application and to when we have the final hearing. So you have this time where there's technically no guardian in place, and the person's 18, and the law looks to them as if they are an adult. So if you need things like doctor's appointments, dentist appointments, all of that, do it before they turn 18, right? So let's get that done before they turn 18, so we don't have anything that pops up in that in-between time period. Parents sometimes get worried. They're like, what if an emergency happens? If we happen to be in that window of time, during that we could petition the court for an emergency temporary guardian while that's pending, right? So there is a fix for it. There's an emergency that we could request. And basically that would say we have a temporary guardian in place until we can get to the hearing. We can't ask for a temporary guardian unless we have that emergency, right? So that emergency would have to trigger our request. So they do the court application, can't do anything until after the 18th birthday, doctor's certification. We also have court-appointed counsel. So what this means is that usually mom and dad come to me, I do the application on behalf of mom and dad. Well, your son or daughter is now considered legally an adult, and you're asking the court to take away and restrict their freedoms. And so the court will appoint counsel to represent him or her, right? And so that court-appointed counsel will then interview the family, they will interview the doctors, and then they will submit a report to the court. 99.9% of the reports say something, well, the families that I work with say something along this. I met with mom and dad, I met with brothers and sisters, guardianship is appropriate based on X, Y, and Z, and mom and dad are the most appropriate people to be the guardian. They've been loving and caring for the person their entire life, and they're willing and able to continue doing so, right? So they're pretty straightforward. Most of the time when I'm working with families that have a child with special needs, it's pretty straightforward in that regard. It becomes a little bit more gray when you have somebody who's elderly that needs a guardianship, right? Then who's the most appropriate person to be the guardian, which one of their children is. So it becomes a little bit different of an analysis when we're dealing with our children who are different here. After that, there's a court hearing. Now, not every county does a court hearing, right? So every county is slightly different. Every judge is slightly different in what they do. So some of them will read all the paperwork we submit, they'll read it over, and then put in their decision and say, yes, guardianship is appropriate, here you go. Some will set it for hearing. The reason why I found is the reason why the judges want to meet the families. They want to talk to the families, and most of the time they want to thank the parents, right? And it sounds so silly, like thank you for being a mom, but for them, not every parent is willing to step up and continue caring for their child after they turn 18, right? And so for the judges in the court, this is very important and very meaningful for them to be able to thank the parents and speak to them one-on-one and say, hey, listen, you've been doing a wonderful job, this is great, thank you so much, right? So a lot of times parents will freak out and say, there's a hearing, I'm scared, what's going to happen, are they going to deny it? It's the exact opposite, right? It's the exact opposite of what we expected. When you are appointed a guardian, there's an annual report that you have to file. It says the person's alive and well and still needs a guardian. And then if there's a financial piece, then this is how much they have in their assets, this is what was spent last year, and this is where their balance is. The other thing people should be thinking about, most of the time child's turning 18, mom and dad, and I say mom and dad generally speaking, it could be mom and mom, could be dad and dad, could be a lot of single families out here. Mom and dad are the first parental choice under the statute to be the guardian, but at some point one parent might pass away before the other, right? You have to start thinking about a successor guardian, a long-term plan. And in that case, sometimes what we'll see is down the road, not with the initial guardianship, but down the road, we will see that parent add on a co-guardian with them, whether it's another adult sibling or another, maybe it's a niece or a nephew who's going to take over that role. And they will add them on as a co-guardian to make sure that there's no gap, right? So if the second parent passes away, then that person's without a guardian. You don't have somebody steering the ship. And so it's important that we think about not just the now solution, but we start thinking about, we'll talk about this a little bit more with the estate planning, we think about that long-term solution for us. All right, so if guardianship is not the right answer, right? So you might have somebody that's in the gray area, maybe they don't need a guardian, maybe they can manage and govern their own affairs, but they need that support still, right? They still need mom and dad to help them with finances or help them with medical decisions, whatever that may be. We can address that and help fill in those gaps and provide the support with some of our estate planning documents, right? So a power of attorney document, right? So that document is where you and then enter the person that we're talking about with the disability, gives another person, their agent, the right to make legal and financial decisions for them, right? To assist them with those decisions, right? So if they need help with banking, the power of attorney document would say, hey, I give mom permission to have access to my bank accounts, to do banking transactions for me, so on and so forth. So that is a way that we can continue to provide them with that financial support, but let them, they're still in control of their decisions. Medical directive. In this document, the way I tend to draft it, it's a live-in will. We include their end-of-life decisions, but you also include in there a healthcare proxy, somebody who can make medical decisions for you if you cannot. And so again, you have an individual with disabilities, if they have the capacity to enter into these documents, they can name a healthcare proxy, somebody else who can make those medical decisions for them if they cannot. The other thing is both of those documents have a HIPAA release in there, so that means mom and dad would be able to get information regarding the medical records if they needed it. So the reason why we put it in the financial document as well is because you call up about a bill that came in, hey, they had this hospital bill, what's this for? They're like, oh, I'm sorry, I can't share confidential information with you, even though you're helping on the financial piece. So we find that we kind of need it in both documents to kind of plug those holes, fill those gaps. Educational proxy, right? So once your child turns 18, the school is going to look to them for all their educational decisions, not to mom and dad. Most of the school districts have their own template form for mom and dad to fill out, or for the individual to fill out, to allow mom and dad to still be involved in the educational process, right? So if the person's going to college, to community college, to a four-year school, to a vocational school, you're going to want to have an educational proxy or have this in a power of attorney document, so that way mom and dad can continue to provide that support for them. And the important thing is they have to have the capacity to execute these documents. They have to understand what they're doing. They have to understand, I mean, obviously, families that don't have a disability, you need to explain some of the legal terms to make sure they understand it. So, they have to understand what they're doing by the document, that they're giving this power to somebody else. But they also need to know that they can take this document back at any point. They can revoke it, right? So it's not permanent in place. So guardianship, you can't revoke, right? So once the court rules the person needs a guardian, you could always go back to court and have the guardianship undone. But the individual can't say, I no longer want to be under guardianship. You can have your son or daughter get angry at you and turn around and rip up the medical directive, and then now you don't have access to anything, right? So they can give you the authority to access their information. They can also take it away. So that is a risk. That doesn't mean that parents are sometimes scared of that. That doesn't mean guardianship is appropriate. It just means making sure that the person understands the documents and that they are in place as long as they want them to be in place. So this is the other side of the guardianship piece. A lot of times individuals that are in this gray area, we'll see sometimes they have a guardianship, but they might develop skills later on. So had an individual that by the time he was 25, 26, was able to start living independently, right? And so at that point, we petitioned the court to change it from plenary guardianship to only a limited guardianship. And then the family was looking down the road to dissolve the guardianship completely, right? So that person just was developing at a different point for that. So every situation is going to be different. Every family is going to be different. All right, moving on to our next topic. Big topic. And I'm going to kind of start from the back and then work my way forward. I mentioned early on, and for those of you that came late, I'll just quickly say, is we talked a little bit about the educational entitlement, that an individual is entitled to stay in school until they are 21, if that's what's needed. The Division of Developmental Disabilities provides supports and services to individuals that have an intellectual or developmental disability, but they do not kick in and start providing services until the individual is 21 years of age, right? Why? Because up until 21, if it's needed, the school district is the one providing those services. So in order to be eligible for services from DDD, we need to make sure we are Medicaid eligible. The easiest way to become Medicaid eligible is by applying for SSI. So we're going to start at the top. Supplementary Security Income. This is through Social Security. It is, you can apply at 18. It provides a monthly amount to an individual who is disabled, who meets the definition of their definition for a disabled adult. And they also have to keep their income and assets below a certain threshold amount, right? So most of the time that means they can't have assets over $2,000, right? So that's actually a small amount when we talk about the big picture of a person's assets, right? So think about the value of your home, that's way more than $2,000, right? So they need to have assets under a certain amount. But when they are eligible for SSI, the application for SSI includes the application for Medicaid in New Jersey. If they're eligible for SSI, they are automatically eligible for Medicaid. So Medicaid provides the health insurance, but it also is a key, so to speak, that opens up the supports and services, right? So a lot of the supports and services through DDD require you to be Medicaid eligible. So even if you're not using the health insurance part of Medicaid, the fact that that person is eligible to receive Medicaid means they're then eligible to receive the supports and services through DDD. So Medicaid, you also need to meet those specific requirements, and Medicaid has an income and resource limit as well. So they need to make sure that we stay below this, about $2,000 in assets. DDD, to be eligible for those services, you need to meet the clinical definitions that they have for disability. And then, like I said, you need to be Medicaid eligible. So that's the key part, is that Medicaid eligibility just unlocks those supports and services. Now, prior to the age of 18, even though your child may meet that definition of disability, Social Security will look to mom and dad to see what income is coming into the household, and the child would not be eligible. So that's why we start that application at 18, because at that point, Social Security will only look to their own resources and income, not to mom and dad's, right? So that's going to start at 18. The other piece is at 18, do the application for SSI and Medicaid. You can also start the application for DDD, right? So DDD will, if eligible, will only provide what we're going to call transition services. So they'll provide a case manager and transition support between the ages of 18 and 21. Like I mentioned, the school district is covering that time period, but they want to help with the transition, right? So they're just going to assign a case manager, caseworker, and then help with transition services. But the important part about applying for this at 18 is DDD requires what's called the NJCAT, New Jersey, it's an assessment tool that they use. What they do is they ask about 150 questions about your child and what they can and can't do. So we talked early on about thinking about our child in the best light possible and trying to think about what they can't do. It's really important that we answer this assessment as accurately as possible, because they'll ask questions like, can they shower independently? It might be like a gray scale, like always, sometimes, rarely. And again, we sometimes think of our child in the best light, and a lot of people are like, yeah, they can shower independently, yes, 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 yes. The important part of this assessment is that once they do the assessment, that is connected to a tier system, and that tier system is assigned a budget. That budget is what pays for those supports and services. The day program, the transportation, the therapies, whatever it is that that individual needs is controlled by that budget. We want to start that application and process at 18, because if we need to appeal that, if they get that wrong, they assign the wrong tier, they're not on their own. At 21, if we start that right when they're turning 21, well, all of a sudden we're fighting with DDD saying it's not the right tier. Now they've graduated from school, they've ended their educational entitlement, and we have no supports in place, right? So we want to start that process early on. Even if all we're getting is transition services and a case manager assigned, fine, but we have that ready to go, right? So a lot of this is just making sure that pieces are ready to go. So that way, when your child reaches that next milestone, it's in place. All right, government entitlements. I know this is a lot, and I see the glossy look to the eyes, and I tell folks this. I give these presentations, we're going to chat about this some more in the next two presentations. I also do a lot of other ones online as well. Come to as many as you need to, right? So I've had 4 years of law school, over 10 years of practice. I still have to look up some of these questions. When clients come to me with some oddball questions or some fact patterns, this is heavy stuff. It's complicated. There's a lot of interplay between different laws and different programs, different timing based on age. So if you're feeling overwhelmed, that's perfectly normal. That's an okay feeling. And so my job is to help break that down. But if this is the first time you're hearing it, don't be overwhelmed by it. We'll just break it down step by step as we go. Government entitlements. So let's move on to here. I want to talk about your estate plan, right? And the reason why this is important, we just talked about those income and resource limits for your child. So if they need to keep their resources under $2,000. We've just spent years setting this up, making sure they have the right supports in place for when they turn 21. We have this. Something happens to you and you pass away. Now here's the example that I'm going to give. You have a modest home, it's worth $250,000. You have 2 children, one who has a disability, one who does not. Without a will, each of those children, when the second parent passes away, will inherit equally, right? So there's an intestacy statute that says it goes to your spouse first, the second spouse to pass away, it goes to the 2 children. In that case, your child has just inherited $125,000. An asset way over our $2,000 limit, right? So now we have just jeopardized everything that we've spent years working to put into place, right? So that's the importance of the estate plan, right? We want to make sure that they're provided for and protected, and that we're not doing anything well intended to jeopardize that. And so a lot of times families don't realize they might have a child named as a secondary beneficiary on a life insurance policy, on a retirement plan. Same thing, if they inherit that, that could jeopardize their benefits, right? So we're going to talk about estate plan. Without an estate plan, obviously that's the scenario that could happen, but there's a couple other things that could happen without having an estate plan. One, the court's going to have to appoint an administrator. You haven't decided who you want that person to be, that person to wrap up your final affairs, to pay off your final debts, to gather your assets, to do a final tax return for you, right? So it's going to be based upon whoever's going to petition the court to do that job. And let's say you have adult children. So all of the adult children have an equal right to fill out those shoes for that particular role, right? So they either have to agree to who's going to take that role on, and the ones that aren't have to disclaim it and say, hey, this is okay, I'm going to let my brother handle it, my sister handle it. When you have a will, you get to decide, this is who I want the executor to be, this is the person most capable of wrapping up my final affairs. You can also give them very specific instructions. You can leave them the passwords they need for your accounts. You can leave them that information so it's not a hunt. Because sometimes I'm working with families and we're trying to track down their last tax return and information so we know what assets exist. If you know who it is that you want to handle that, you can have that information prepared for them if they need that information. We talked about your assets. How your assets go is governed by an intestacy statute. So without a plan, you have no control over that. Your personal representative, the administrator, will have to post a bond, right? So that $250,000 house, they will have to post a bond just to serve as your administrator, right? In your will, we usually add language that says, I waive the bond for the executor, right? And so that gets out of needing that. But a bond is it's basically an insurance policy that says you're going to handle this correctly, right? And if not, you're insured up to the amount of the estate if you mess up, right? So the court does require a bond unless we have that waived in a will, right? So that's important that we have that. And then guardianship, right? So if you have minor children or even a child with a disability, you want to be naming who that person is, who's going to be your successor. We still have to go back to court and have a court order saying that that person is now the guardian, but you can dictate who the best person is for that, right? And that solves a lot of fighting that, as to who's going to do it. And it also makes your children feel better, right? When they know mom's thought about this, dad thought about this, they've decided so-and-so is going to take care of me, right? So it helps on that end as well. All right, so talked about the will, and I mentioned some of these as I was talking about. Yes?
I have a little question
sure.
before I forget.
Yeah.
If you have all that in place,
Yep.
and you have this special needs trust fund,
Okay.
and you have allocated who's going to take your place,
Yep.
and that's in your will as well,
Mm-hmm.
can anyone contest that?
So a will could be contested for several reasons, right? And so they can contest and say that there was duress when you were creating your will, maybe that's not the current will. So depending on the circumstances, people can contest the will. It's just when you have it in writing, it becomes a lot harder to contest the will when there's formalities that are done correctly with having it. But usually the most common ways to contest the will are the person lacks capacity when they made this. We see this a lot with elderly people. All of a sudden, they've changed their will right before they passed away. Did they really have capacity to make those changes on their deathbed? Also, undue duress. So we see, again, a lot of times with the elderly, we have one child who might be caring for the parent, and then all of a sudden the will gets changed, and everything is being left to that child. Now, it could very well be that the parent said, they've been taking care of me, and therefore I'm going to reward them with this, maybe whatever the reasons are that are personal, but we sometimes see challenges when we have those sort of scenarios. So those are the more common types of challenges, but it's challenges, if something's done with all the formalities, something basic like this, we don't see a lot of those type of challenging, like,
So,
yeah.
you're pretty safe.
Right, right, and that's the thing, is we want to put this in place, we want to put all the formalities there. The other piece that we have is sometimes we'll see people that'll make a new will, and they won't revoke the old will. They'll just put it off to the side, and they'll show one set of children one will, one set of children another will. Well, now they've passed away, now the kids are fighting. I know.
That's amazing. That's shocking.
Yeah, so, when I work with clients, if you're making a new will, we're ripping up the old will that's getting shredded, that's done. It's the old will that's gone. Here's your new one. So we can avoid sort of those games, right? So when we see that, there's usually some other factors that are going on. But we're going to go through, so some of the things you mentioned, because you mentioned a whole bunch in there, having that special needs trust, we're going to cover that in a second here. So when you do the will, you get to say who your executor is. This is the person I mentioned who's going to wrap up your final affairs, do the final tax return, gather your assets, file anything that's needed. I mentioned that scenario where you have your assets passing to your two children. When you do a will, in the will, the child with a disability, we're not going to leave it to them directly. We're going to leave it to his or her special needs trust, right? As long as the trust is drafted correctly, it has the right language in it, Social Security, Medicaid have said it does not count as an asset. It does not count towards those resource limits, right? So it's important that it be a proper special needs trust. But we're going to direct it there. Now this is, yes?
Just a quick question. So on the special needs trust, if you already funded that, that's not an asset. That's where.
If you've already funded it, yeah, it's not an asset to them. Exactly. A lot of times, so most of the time it's not funded until people pass away. However, what I tell folks is, they come to me, the parents come to me, we draft a special needs trust. I will usually put the parents as the trustee. And they will say to me is, well, wait a second, if it's not going to be funded until I'm dead, why am I the trustee? The trustee is the person that steers the ship for the trust, like makes the decisions about how the money gets spent, does the accounting. And the reason why is I tell them, listen, you want to tell any other family member, grandma, grandpa, aunts and uncles, godparents, if you're going to leave money to my child, make sure you leave it to their trust and not to them directly. right? So there, in theory, can be funded while you're alive, and you want to be the captain of that ship while you're here. So we go ahead and set that up. So yeah.
I mean, I found that, like, for example, my insurance anymore.
Okay.
You only can name an individual, you can't name a trust. So what happens there?
So we usually do with, that's a great question. So when I did the estate plans, I actually draft the entire trust. So there's two ways that practitioners, lawyers will handle it. Sometimes they'll say in my will, upon my death, create the special needs trust. Well, that becomes problematic because it's not in existence right now. We draft the special needs trust right now, and we actually apply for and get an EIN number, right? So when we're filling out those beneficiary forms, we are providing them with a copy of the name of the trust documents themselves, and we have the actual EIN number, because that's the biggest issue is I can't leave it to a trust because I don't have that EIN number. Well, we have all that in place. We can go ahead and fill out those forms and get that set up for that. So we're going to leave the property to the special needs trust. The other thing we're going to do in here is we're going to say if we have minor children, we're going to say who we want the guardian to be. Right? If we have an adult that's a disabled adult child that's under guardianship, we also want to name who that guardian is going to be, right? So who your backup is. The other thing I just mentioned here, that if you have minor children, sometimes a 19-year-old who does not have a disability will not make very good decisions with $125,000, right? So we may want things to go into what's called a minor trust, right? So minor trust, even though it says minor, would basically say if they're under a certain age, it's going to be held in trust until maybe they're 25 or maybe 30, and they can have access to that money through the trustee, right? So the trustee will make the decisions. Usually it's for things like schooling or marriage or a car, things obviously mom and dad would want that money to be spent on, but we would have that there until these different intervals. And if it's not spent, then the trustee would say, here's your, $75,000, here's the balance that's left in the trust at those intervals. Right?
Is it an either or, minor trust versus special needs trust, or
Yeah, it's going to be an either or. So
why do you set up one versus either?
Yes. So the special needs trust is going to have very specific language in it that allows it to be exempt from those Medicaid and Social Security. A minor trust is just saying we want to have it held and overseen by a more responsible adult. For now,
If you put it in the minor trust,
it's going to count as an asset. Correct. And so the minor trust, when we do something like this, is we just put language in the will that says, if needed, the minor trust will be set up, right? So it's pretty straightforward. For the special needs trust, we actually want to go through and draft all of that language now to make sure that we're hitting all of those points so it doesn't count. The other thing is those non-appropriate assets, right? So we talk about it as an estate plan. Sometimes people will say, I just need a simple will. This isn't a simple will, right? We need an estate plan. We need to plan for all of your assets. And I sit down and I ask people, like, we have a checklist. We go through all of this systematically because we want to make sure something doesn't accidentally get left to them, right? So you have that life insurance policy, you have that retirement account, you have those benefits through work, and to make sure that we set it up so we have the beneficiary designation as that special needs trust. Because if we didn't and we take care of it with the will, we could end up forgetting about it and we could mess up our entire plan if we don't take care of these other assets, right? So, all right, so special needs trust. I know we've talked about most of these, but I want to hit on this and explain two concepts to you. So there are actually two types of special needs trust. Right? There's what's called a first party and a third party. The one we are talking about right now is a third party special needs trust, sometimes also called a supplemental trust. The first party trust, remember that example we're using where your child accidentally inherits the $125,000? There is a fix for that. It is not a cheap fix, but there is a fix for that, right? So that is where we would petition the court to ask the court's permission, and we'd have to give notice to Medicaid and DDD to have a first-party special needs trust created. That is what's called a Medicaid payback trust. That means when your child passes away after they're done needing the money in the trust, anything left over goes to Medicaid for all the supports and services they've received in their life. Means usually there's nothing left over. In your trust, the one you set up as part of your will, you get to decide where it goes afterwards. If you have other children, if you have nieces and nephews, if you have a charity or an organization that's provided you with a lot of support along the way, you want to make a nice donation to the library, you can do that in your special needs trust, right? Right? You like that.
Yes, I did.
But you can go ahead and you get to decide. It's your money. It's your not your inheritance. It's your estate, right? It's your child's inheritance, but it's your estate. You get to control who gets that next if your child does not meet all of that, right? So that's one of the biggest distinctions between the first party and the third party special needs trust.
You're saying the first party you can do that with, or the third?
The third party.
Third party. You could designate it to
Yep.
somebody.
Because you are the third party. So the first party means that it's touched your child's hands. Like it has become their asset at one point, and then therefore we need to put it in there, put it into trust. So a lot of times we may have to, when we're applying for guardianship, sometimes the child may have accumulated a lot of bonds over their lifetime. They may have savings already that grandma and grandpa have given them. So we sometimes are applying for guardianship. We want to apply for SSI and Medicaid, but the child is already have $30,000 or $40,000. So we need to petition the court for that first party special needs trust. Easier to do as part of the guardianship application, not necessarily easier, but we're already going to the court with the guardianship application. We fold it all together in one application. So we talked about funding the special needs trust, usually funded as part of your will, could be funded from these other policies. Sometimes people will say, hey, I want to do a small life insurance policy or something to fund it. A whole bunch of different ways that it can be funded. You want to make sure grandma and grandpa know about it because you don't want them accidentally giving something to your child. The money is used, and I want to be clear about this, to supplement the benefits they are receiving, right? So that's the key, is that in order for them to continue receiving those government benefits, they can't overlap and use the money for the same types of things, right? So if Medicaid's covering therapies, they can't be using that money for therapy. Now, if there's extra therapies that aren't covered, then you can use that money. This is designed so that they can still enjoy everything that mom and dad would do for them while they were alive. Vacations, extra furniture, a new iPad, maybe they need a new phone, all of those extras. For the food, clothing, and shelter is provided by SSI and Medicaid, right? So this is meant to supplement. Yes?
Question.
Yes.
So, a lot of things I see happening today is that when people pass away, a lot of people form like GoFundMe pages to like raise money for the deceased. Can money from like sources like that be used to fund the special needs trust? Could that be put into like gifts,
Right.
Gift donations like that?
So
Is that possible?
you could, right? You
Right.
could. But we're going to talk about a New Jersey Able account.
Okay.
And that actually would be a better use of it. But yeah, so this third-party trust can be funded from other sources. So it would really depend on how that GoFundMe is set up. So if it's set up for that individual, then it becomes that individual's assets. So we got to think about that, like, oh, mom and dad have passed away. Now we have a GoFundMe page for their child, opposed to we have a GoFundMe page for the estate. If it goes to the estate, our will says it goes to the trust. So so it's very careful how that GoFundMe page. But that's a great question. But there's also another good way that we can address that with the New Jersey Able accounts. All right. So we covered special needs trust. Now this, I know I'm coming back for. We're doing a whole presentation on this, right? We're going to do a whole presentation on the guardianship and the transition to adulthood. We're going to talk about those benefits a little bit more, but we're going to definitely be covering this in more detail because there's a lot here. A lot of times we get questions about how do I choose the right trustee? How do I choose the successor trustee? We can talk a lot about that. The other document part of your estate plan, we want to think about, we talked about planning for your death, right? So sorry, it's more of a topic. We got a plan. We also have to plan for your incapacity. So if you're not here physically or mentally for your child, we need to know how we're going to care for them, right? So I mentioned that power of attorney document early on as a way to, an alternative to a guardianship if appropriate. Well, you're going to want a power of attorney document for yourself, right? To name somebody else who can make legal and financial decisions for you if you are unable to. You're in a car accident, you can't get to the bank. You want to know who can get to the bank for you, right? Who can do that? Most of the time you name your spouse first, then you name a backup. When is this used? Again, used an example like that. Or sometimes you have, a lot of times, elderly people, they can't get out to the bank. They'll do a power of attorney document. You can name a standby guardian. So if you should happen to need a guardian for yourself, this is who I would want to be my guardian, right? So you can identify that person. But if you are the guardian for somebody else, right? So this is a disabled adult child who's under guardianship. You can put in here that somebody can temporarily act on your behalf for up to 6 weeks in an emergency and who that person is, right? So instead of having to petition the court. Seeing this used with a parent who had to go for cancer treatment, right? So obviously still had all the faculties to make decisions about their child, but physically couldn't because they were ill. They couldn't be the one going to the school for drop-off. And so they, in their power of attorney document, we included language, so that way that person could go to the school and manage that for their children as well. All right, so if you are a guardian for somebody else, you want to make sure that if you can't make decisions, how you're making them for yourself, and then folding that person in as well. The other piece, this is the other document that's used while you're still alive. It's the Advanced Directive, Medical Directive. It covers your healthcare decisions, what end-of-life decisions you would want for yourself. Life support, do you want a do not resuscitate order? Do you want pain medication if that's going to hasten your death? A lot of times people, will want to spell that out so their family members know what their final wishes are. Have a HIPAA release in here, and then a healthcare proxy. So who will make medical decisions for you if you cannot, right? As long as you are capable and able to make medical decisions, this document does not kick in, right? So if you are capable, this does not kick in. If you can't, that's when this is going to kick in, where that other person's going to be able to. You're in a car accident, they need to do emergency surgery, you're not conscious, your healthcare proxy is going to say, go ahead, operate if that's the best decision for you. If you are a guardian for an adult disabled child, you can't make medical decisions for yourself, you can't make medical decisions for him and her. So you're going to want to fold them into your document and say, these are the decisions I would want for them, right? So the same, and it may or may not be based on your wishes, but these are the end-of-life decisions I want for me, and if I can't make them, these are the same ones I want for my child, or different ones if different ones apply. But you want to spell that out so we're covering both incapacity and then if you're not here, for death. All right, so moving on to our last and final slide for tonight here. New Jersey ABLE accounts, right? It doesn't really fit into my slide, my other slides so well, so I put this at the end. But I tell people to think about a New Jersey ABLE account like a tool, right? So you have a hammer and a screwdriver, you're working on a project, you don't necessarily need both of them for every project, but you have both of them in your toolbox, right? So that's how we think about this, right? We have the special needs trust set up, we want to think about an ABLE account. So, I don't know if you guys have heard of 529 college savings accounts. Most people are very familiar with those types of savings accounts. A lot of times people would set them up for a child and not realizing whether or not the child would go to college. Well, now all of a sudden the child's 17 and they have a disability and they're not going to be going to college. So now you're like, well, what do I do with the money? This is actually, the New Jersey ABLE accounts fall under the 529, that statute of the IRS code. So it's not a college savings account, but it is a very specific type of savings account for an individual with disabilities, right? So you have to meet the definition of being a disabled person to be able to set up this account. And then any growth, because it's an investment account, much like a college savings account, the growth that happens in the account grows tax-free. So that's a little bit of an advantage here. So there's always going to be a trade-off with what the government allows and what the restrictions are. So we talked about that first-party special needs trust, where if we have to petition the court to put money in, Medicaid receives anything that's left over. That's the same sort of catch with a New Jersey ABLE account, right? If we set one of these up and the person passes away, the person who has a disability, anything that's left over in this account would go back to Medicaid, right? So that's just to keep in mind. Now there's pluses to this, right? So I just want people to understand that is the downside, but there are pluses to it. Number one, you or somebody else or that individual can put up to $15,000 per year into a New Jersey ABLE account. The government says we will not count that towards your resource limits, right? So the example where I said we're applying for guardianship, they have a whole lot of bonds from grandma and grandpa, we're gonna throw it in a New Jersey ABLE account. Somebody sets up a GoFundMe page, it's under the $15,000, we're gonna set up a New Jersey ABLE account and throw it in there, right? So even that individual could put their own personal money into that account, and that's not gonna count. Up to $15,000 per year. If that individual is working, they're earning their own income, there's actually a higher limit that they could put in. I think it's like another $13,000 and change per year. Now, This will not jeopardize your benefits until this reaches around the $100,000 mark, right? So most of the time, people have smaller amounts that are in these type of accounts because we want to spend the money in this account. We don't want Medicaid to be the beneficiary. The reason why we also like these accounts is that you can spend this money on a qualified disability expense, right? So this is a very broad category of what's included. One of our more advanced topics we're going to talk about with the special needs trust, there's restrictions on how the money can be used towards housing. Because if it's used for housing, Social Security will count it as income. Remember I said we have both income and resource limits, right? And so we have to be very careful on how money is spent from that special needs trust. However, here, New Jersey Able account, you can use it on housing, and Social Security said we will not count it as income. So we use this as a tool sometimes when the individual needs to spend money on housing. So maybe that person's independent. They can live independently, they still need support from mom and dad, and maybe their rent is a little bit more than what they have coming in every month, and they need to pull it either from a trust or pull it from the ABLE account. We're going to want to make sure we're pulling it from an ABLE account because that's not going to count towards those income limits, right? So there's a lot of planning involved, and a lot of this is going to depend on different circumstances. The reason why I talk about this now is if you have a child turning 18, we want to think about, do they have anything for mom and dad, grandma and grandpa, any savings along the way? Let's get an ABLE account set up and get the money in the ABLE account so that way it doesn't count as a resource when we go to apply for those entitlements when they turn 18, right? So that's important to get that set up. The other piece is there needs to be specific language if you are a guardian in the order from the court in order to set up the ABLE account, right? So if you can do it now before the child's 18, go ahead and get it set up so it's in place and you have it ready to go. Right, so I know this is a lot. By this point, people are completely glazed over with like the interplay between the special needs trust and the ABLE account. And that's why we're going to talk about that in more detail down the road. But this is, again, it's a great tool for saving money, and it's a great way, it's less expensive than having to petition the court for that first party trust. You got a question? I can tell. I see the look. I see the look.
I'm good at all this, but my one child is disabled, but he's young. So, like, I don't know.
So
So,
so if you have, like, things like when grandma and grandpa want to give savings bond, or, you know, if you have that stuff where you're starting that savings and they're young, set this up and put it there. Right, so it's just going to be like, it's literally a bank account. It's an investment account. It's going to grow. You have little pie charts. You get to choose how it's invested. And then there's a checking account option with a debit card if you need to access that money.
But the plan for his future, is this something that I would do like before, like sooner? I mean,
You have to wait till 18.
No, you don't have to
wait until they're older. You want to do it now.
Yeah, I mean, you know, I mean,
questions,
But
sorry.
this would be my recommendation. If you know your child is going to need those benefits at 18,
I don't know.
Right.
I mean, right now I would say yes.
Right.
But they're your children. Of course, you want to think highly of them. That it's scary.
Right.
You know.
Right, and so, you know, in order to open up this account, they need to meet the definition of disabled, which is
Whose
pretty,
definition?
the New Jersey ABLE, but it's the equivalent of Social Security. It's pretty broad.
But do you have to have a Social Security ruling to do that?
If you have it already, it's
And
automatic.
that's automatic, but if
So
you
then
don't have one and you
then you
haven't
just have to get a letter
applied.
from your doctor.
And who sets it up?
So a parent, so you could literally go to the New Jersey ABLE website and as the parent, go ahead and set up the account itself. Say, hey, they're under 18, set it up. You can also go to my website. I have a resource page on my website where I put all of these links, right? So I put a link to the court with the guardianship and the video about what it means to be a guardian from the court. I have a link to New Jersey ABLE. I have a link to SSI. I try to keep that in one location for parents in case they're like, what did she talk about? I forgot this. You can go to my website. I have a resource page that I'm building on this. Yes.
Not using this, what is the appropriate way to bring down the assets so they are below 2,000?
So spending them and spending them in ways that are meaningful on the individual, right? So not gifting them to other people, but doing things like if they need new clothes, if they need new furniture, if they need an iPad or a computer for school, spending it on the individual itself, depending on how much, I mean, just for the sake of the hypothetical, how much in terms of assets.
Say if there was 5,000, how would you bring that 3,000?
Probably spending, like I said, it would either be setting it up in this account. It would be not cost effective to do a first party special needs trust. And that, I would look to see what that individual needed. Do they need furniture?
You couldn't not do this a month before they turn 18.
Do this account?
No, draw down those,
You can spend that before they turn 18. Now, Medicaid has what's called a 5-year look back. They're gonna look, 5 years at how that money's been spent.
So they will see you put up this account, so what
And
does that mean?
This, under the law, is exempt from that.
So if you put it in this account, it's exempt,
You're good. You are completely good, right? So it doesn't count towards that spend.
but you can only put 15 in.
Per
But if you
year,
spend it
per
down
year.
and look at it.
Yeah,
So-
but if they're close to 18, then you got the 1 year, basically.
Not per month.
no, this is complicated here, this
Yeah.
business here.
Yeah.
If you had 3,000, just hypothetically,
Yeah.
if you had $3,000 in bonds or whatever savings account.
Yeah.
You could not just use them for something for the child,
Yeah, you can.
keep the receipt, and there's this 5-year thing where it has to be done.
Right, so in that, spend them for the child and keep the receipts for what you've spent it on. So as long as it's for the child, that's going to be fine. It's when people start to gift money to somebody else. Oh, I gave mom $500, I gave my brother $500. That's where Medicaid starts to question it.
From their account.
From
So you're
their
giving it to their
account.
family.
Okay.
Right, so,
Now, this account or a special needs account?
No,
A
just
regular
Regular
Right.
savings
This
account.
5-year look back, the
Yeah.
only, not to get around it, but the only way that they're gonna know that it existed is if it was associated with a social security number.
correct.
Only
Correct.
that,
Yes.
Yours or theirs?
Well,
theirs.
so it's theirs because we're looking at their assets.
So if you open a bank account with your kid's social security number, they're gonna look at that.
Correct, and that's
But
what,
if you set the account up in your name and put the money in it for them, they're not gonna look at that.
right, I mean,
So it's
right.
all how you.
You'll look at that.
But you
program.
can't,
But it's, right.
you can't just transfer it from one bank account
To a,
to another one with a different social security number without them saying.
that's gonna
like,
see a gift, that's gonna look as a gift, because it's going from one person, one social,
So
to another person.
that was not spent on.
Correct, so that's gonna be a trigger.
Okay.
Yep.
Thank
Yeah. And no, it's not easy, so that's why when I say to folks, when your child's turning 18, if you have all the pieces in place, meet with me about 3 months in advance. If not, let's meet about 6 months in advance, right? So if we have to set this up, or we have to worry about, depending also, this is $15,000 per year, but depending on when that person turns 18, right? We have December and we have January, back to back. So you could do $15,000 in December and $15,000 in January. Right? So there are ways to sit down and right.
Yeah, because they'll get social security at 18, whether they're in school or not, or if they.
Right,
If they're
and when they apply, right? So maybe you have to hold off on applying a couple months because maybe their birthday's in December, but we haven't put the assets in place yet, so we don't apply till March. But we transfer the assets, we make sure we get everything set up so it's not going to jeopardize them, and then we do the application.
But you can still apply at 18, even if they're in school, that's a separate
Yes,
question.
correct, yep, absolutely, right. But you don't want to apply, but to a separate answer, not to your question, but you don't want to apply if you haven't made sure that the assets are right, because then it's going to get denied, and then you're going to be stuck in this like, well then, what happened?
Then you're gonna spend this money.
Right.
Ridiculous.
And-
Almost, just to get rid of it.
And we use, and so I want to talk about this. The reason why this became very, very important the last year and a half is we had those stimulus checks from the government. They were $1,200. So I had individuals that were receiving this. They were individuals that were in day programs, right? So now they just got $1,200. But because everything was shut down, they couldn't spend a penny. They couldn't spend anything. Well, now they just got their Social Security check in. Maybe it was $700. Now everything's still shut down. Now they get another $700. Well, now what are they doing, right? So we were in this catch-22, and so parents were calling me, freaking out. We started to set up able accounts, right? So that's why I say, like, it's a tool.
They'll
If
put
you
money there so the account never goes above.
Right. So if you have $50, open the account, get it set up. You may not need it, and it's just set there, open up, ready to go. But if you have something that happened, who could have predicted with the stimulus checks and all of that?
And it's easy to take money out of this account.
So there's the investment part, which functions like a typical investment account, that if you need money, you have to put the a request with it and they mail you a check. You can set up to have a checking account connected to it that has a debit card and the check on there, right? So I tell families, set that up, have that, so you have the easy access, you don't have to wait for the check to come in. Another question I get, okay, Ted.
These stimulus checks, so they are going to the person who's filing income tax, the parents. Okay, so, but that stimulus portion that's coming back as a refund or a direct payment, that is something that should be going into an account for the child?
No, these are ones that went directly to the individuals. They were like in their 20s,
Oh,
right? Yeah, so
okay.
these were ones that went directly to them. They were already adults, not ones that were getting it from their parents.
Okay.
So, no, good question.
If you're 18, it would go directly to them.
Correct. Yeah. And so what happened was so Social Security and the IRS realized that this was a problem with disabled adults. So then Social Security allowed you 12 months to spend down that $1,200, so $100 a month in theory, to get below that $2,000 limit. So if you had the stimulus amount going to that account and you're at $3,200, you could be at that the $2,000 plus the $1,200. You could stay there for a year. The problem was everything was closed and it was just so hard. But we ended up doing a lot of iPads because folks that were in a group home, we couldn't get access to them, right? You couldn't even go in and visit. So we found ourselves buying iPads for those individuals, and all of a sudden technology became, okay, how do we teach them how to use this so we can call them and communicate with them? So we did find ways to use it within the rules and ways that were meaningful, right, to those individuals. But it was a little bit challenging at the time.
So that stimulus, David did get all the stimulus check, and do you have to have receipts for what you spend it for them?
Not the stimulus check.
Not the stimulus check?
No, the key is when they're receiving money from SSI. SSI is intending that to food, clothing, and shelter to cover their basic needs.
Okay.
Right, and so as long as you're using it for them, we
Okay.
end up seeing red flags when it's going into a household account, or we're seeing it being used for the parents' bills and
Right.
car payments, and they don't have a car. Yeah.
Right.
Yeah.
With like say if they are living at home,
Yeah.
have SSI. Now you get your water bill. You divide it by the 3 people that live there.
So when we're applying for SSI, what we want to do is look at when they're living at home, whether or not we want to have them contributing and paying rent and setting up a lease. Because if they don't, we don't do the lease option. Social Security is going to impute to them a portion of the household expenses and then reduce their SSI. So a lot of times we will figure out what those expenses are. We will determine based on the fair market value what a reasonable amount is for rent. Put a lease in place, and then just do a flat amount every month instead of having to.
Gotcha.
Yeah.
So you said your next session is going to be more, because I have a ton of because you got to do it right. I mean, I've heard our stories, right? So
you questionnaire every year.
doing this, we're hearing from other parents that have been through this,
They
how
find
horrific it
how
is.
much you spend.
So I'm trying to
on
learn from the mistakes of others
and food.
and try not to make as many mistakes, right? Because you're going to trip up on someone, but.
Medical.
Just want it all integrated.
Medicaid takes care of that.
That's what I'm getting at.
Whole
You
house.
have to think it all the way through, and all the documents have to consider the other programs, the other application, everything, yes, just that to be done.
Right, and that's, you're absolutely
And I
right.
have some things in place, I think I have it in place correctly, really have it in place correctly, you know what I mean? So it depends on who
And
you talk
it's
to.
under our house.
Right, well,
We have to
we can do
figure
the
out,
presentation on
you know, that
transition
you're
to
gonna spend
adulthood.
all that
Talk
money.
a little bit more about the SSI and that application as well, but you're right, there are ways, like I just had a mom recently reach out to me and say that she's tried, every time she sent in a lease to Social Security, it basically resulted in her child losing money. And she's like, I don't understand, and what we figured out was that she was, the lease was exceeding the amount that the person was receiving. Right, so we were like, wait a second, mathematically this doesn't work. And she's like, but that's the fair market value. And I said, that's the fair market value if she rented out your home, divided by a third. Right, she's renting out a room, right? So let's pull up on Craigslist, what is a room rental, right? That's a different analysis because does your child if they're living there as an adult, have the right to come in and redecorate everything? Do they have the right to say, hey, I'm knocking this wall down, I'm doing this, I'm doing that? It's not their, it is their house, but it's not their house, right? They don't make those decisions. Even when somebody's renting from you, they don't make those decisions. Their rent reflects that, right? So making sure that it's based on what they have. They have a room, they rent, they have access to the common areas.
Okay. Will you go over the assessment, because that's another thing that.
The NJCAT?
Yeah, you hear a lot of people saying,
We can
make
chat
sure you
about
tell them that, yeah, they can put their pants on, but then they may walk outside and the pants will drop because they don't snap it right, or different things like that, because.
Right, and what I'll do is when I go through the guardianship one, I talk about some more, and I did a big broad overview, so like these categories, I talk about very specific questions. Like I have probably like 16-page intake form that I do, and it's conversational with the parents, so it's not like we're going,
Yeah, I mean, Sophia can get dressed, right? But it may take her an hour. We gotta leave in 10 minutes. So I don't have that hour.
So you need,
But the assessment says, well, she can get
she can get
dressed.
dressed. So we'll take a look at, I'll bring, there are some sample NJCAT questions, and so I'll bring those, and we'll take a look at those, so that way we have an idea of what that looks like.
And like, I guess the doctors want to help, right? Because you can say, hey, Sophia, can you drive? She's like, yeah, I can drive, but you really can't. Like, you know what I mean? Or, can you shop for yourself? Well, sure, I can cook.
Right, right.
Yeah, to
And you
answer
start that.
some of the things that you're saying, I was told, and this, because we did that whole questionnaire for the tier questions, and I think there were like, I don't know how many pages. They were very specific. And you want to say yes, but you just have to think in your head, if you weren't there.
Exactly, yeah, exactly. But
If you
they
weren't
think
there.
that way, though. And then
Oh,
they
yeah,
ask
I mean,
Sophia
yeah,
questions,
they
right?
just if you think that way, that's the way they're going to assess your child.
Oh, is that okay?
questions ahead of time? So there is a sample questionnaire that they make available that we can
That you can read through and see
Yes.
how
But
specific
if
it
I
is.
say, if
Yeah.
I answer it this
Right.
way, then they're gonna have a nurse or somebody come in, right? And do the assessment on the kids, so she can do something totally different.
Well, and they also need to meet the clinical definition, right? So keep in mind, they need to meet the clinical definition, but then doing the interview and the assessment, they were doing it by phone, sometimes they were doing it in person, depending on what COVID allowed. But I think they're back to doing it by phone. I'm not, I think a lot of government,
They need to do it line by phone.
yeah, so they have it, but you're right, at one point they were coming out and they were doing this, and again, it's a balance between being accurate, but being correct, in a very technical, hyper sense, because that's going to matter for what they need. So yeah, we do have questions, we can take a look at those questions, they reflect, basically, there's a sample of them, but they reflect what the entire assessment is like, so we can go through that, and usually what I do is, I tell folks, sometimes I'll even have them fill it out themselves, and then we'll chat about it, right? Like, just so, you fill it out, you tell me where you're struggling, you tell me which questions are, and then we can zone in and talk about your child.
I have a little question. For younger parents with kids who now, like say, like in your situation, who's seeing this whole thing as, oh my God, right? Is there a roadmap or something that probably wasn't around a few years ago, but some of you probably didn't have back then? Is there a roadmap out, something that makes it easy to kind of like at least give a direction as to where to look for to start out?
I think, can I answer that? Because, because my son is 47. I've been through it all. I think the best way to look at it is age appropriate, and look ahead, not like your child to my child, or even like 30 years old or 18. You're going to have to deal with situations at school, and that's a whole other set of rules.
Yeah.
So, like when David was, I'm going to say 16, and I found out about guardianship, that's when I started thinking, we better look into this.
Yeah.
Like this is just too much. I'm thinking about you right now. It's just too much. Because you're, how old is your child?
Oh, he's only gonna be 5.
Okay, but still, these are things that you should know.
Yeah.
But I don't think you should be thinking about guardianship now.
Yeah, I mean, I guess I just.
I don't know, maybe I'm wrong.
Yeah.
No, I think you're right. You're on point, because
It is too much.
It is overwhelming. So if you have a young child, the two things that I tell parents is start it's like the airplane where you put your oxygen mask on first for them. Think about your estate plan, right? Because something could happen to you today when they're 5 or happen when they're 45, right? So you never know if that's gonna happen, but you have that plan in place to care for yourself and then for your children.
Yeah.
And then the educational piece, right? So you already have the IEP in place, making sure that, you know, he is getting the supports and services he needs that are appropriate for him, right? Making
Right.
sure that he has those evaluations every 3 years and making sure that you learn how to be an advocate for him. I say, and I don't know if you can, joining Facebook groups, right? Joining Facebook groups that are out there with other moms, even if you just sit back and listen sometimes or watch the comments, now not all of the advice is accurate, but it's great for resources, for finding out about things that are going on. But I sit there and I'm part of those Facebook groups because I like to know what's going on with my clients, right? Like I want to know what the issues are, what they're concerned about, what's on their mind. But finding something that's geared towards his age group for like younger kids, there's a couple that I'm thinking of, but I just don't know the full.
Yeah, I mean, my son, he has autism. And then he just was diagnosed with apraxia of speech, so he's nonverbal. And, you know, obviously he's definitely more severe, you know, I mean, it's such a broad spectrum.
Right.
And obviously he's still young, so you only hope and pray.
Right.
But obviously I can't turn my eyes to it either and be in denial, maybe.
Right.
I was in denial in the beginning.
Register it with the state, do the things that you can do like early and do them now. I mean, look, my daughter's 17, right? But you have to be there. That's the best advice I can give you.
Yeah.
You're the best advocate. Do not let the school talk you into anything at any time, ever.
That's why you have to be educated, like this lady, you know, go to anything and anything you can just to get educated, and then you'll be fine.
Yep.
I just wanted to say, going along with what you just said, I'm a retired teacher of 5th grade, and the parents were such wonderful advocates for their children. And they would come in, now, within the realm of a regular classroom, you might see someone, the problems were not severe. For example, we didn't have Down syndrome, or we didn't have other severe handicapped children, but we would have maybe a mildly autistic child that was not diagnosed, maybe, or we might have a child, one time I had a child who had little or no reading skills in the 5th grade. Most of the time, the parents were so wonderful and really standing up to, well, they wanted to know everything. We'd sit down, the teacher was there, we'd sit down with the child study team, with the psychologist. There were times that the parents would not go for a classification because they allowed this to go on. Now, in the 5th grade, kid can't read. You know, they blame the school, but I wanted to say to the mother, where were you?
It's both sides, but the thing now, Sophie went to Belmar.
Yeah.
Okay?
Thank you, Tina.
That's advice.
Thank you for coming.
And for with honey, right? So you have to be involved, you have to be present, and you have to advocate.
Absolutely.
Okay,
You can't wait for the school
They're-
to offer you, they're not going to ask.
Yes, you have to ask.
Right, well, this is last year preschool, and now I'm thinking, are they gonna even be able to give him what he needs?
Where, Belmar?
Yes, yeah.
Yeah, they can, and they have to, and they will. And if it's not appropriate there,
Do an out of
out of placement, but remember, you know your child better than
Yeah.
anyone in that building
That's
across the
exactly
street.
right.
And there are, you know, it's changed over time, there, right?
Mhm.
You know,
Yeah.
so Sophia said many things, but the thing is that as long as you have to, at the end of the day, know it's the best thing for him.
Yeah.
And
No one
only
knows
you
better
will
than
know
you.
that.
No one knows
Only
that.
you will
And
know that.
advice I tell the parents is there are times where, obviously, I'm an attorney, right? So at some point I'm gonna say, like, you really should get an attorney involved. But sometimes parents say, I just can't afford an attorney, right? That's the reality. I will tell them, I would rather you do the complaint on your own than not do something because you can't afford it, right? Even if it's like appealing Social Security, filing due process against the school, just if you have to fight for it, if you can, you obviously get the best people. You wouldn't go and do surgery without a doctor, but if you have to, if your child's bleeding and you need to tape them up, you're gonna tape them up, you're gonna take care of that, right? So it's the same type of thing. If you have to go ahead and do something, you go ahead and do something. Like, don't let the legal process scare you.
No.
Yeah.
Every time you do something, you really should know your facts
Yeah.
and then put it in a letter. Because sometimes, am I right?
Yep, absolutely,
Am I right?
absolutely.
Because if you don't put it in a letter, it's not documented.
Everything
And-
has to
and
be
it's-
Everything has to be written.
In writing, no one can claim it is now.
And everybody's experience with Belmar is different, right? So
Mhm.
I had a great experience with Belmar because I was there. You'll talk to similar parents or parents in Belmar and they're like, oh, I had to get lawyers, we had a fight.
You're not necessary.
It's
It's
not
not
right.
the superintendent and who's sitting in charge too.
Well,
It's
it
not
depends, but
necessary.
I went through multiples there with Sophia, she didn't have just one, right? But it's just, going and not, show me, let me sit in that classroom.
There's
Let me
Right.
see what's going on. You have that right as a parent to observe her in the school.
Absolutely.
There's another set of presentations that,
I'll just put it on IEPs.
like I said, there's another set of
The
presentations that I
IEPs.
do that I don't have scheduled here, but if Louis would want me to down in the future, we could always chat about that. But I do two
we talked
presentations
about
on
that,
special
right?
education. One is on
IEP.
parental rights, where I go through
And the
everything
yellow
that,
book.
yeah, everything that
Your
you're.
card's there too.
Yeah, my card is there. But I go through everything that you're entitled to as a parent. I go through that IEP process. I go through all the key players that should be there, so you know that inside and out what your rights are. And then I do a second one on the due process and mediation, right? So if you have to go at that alone, you're not scared, right? So I want families to understand that. So that's a whole different, like.
I
Yeah.
know.
That's what I'm saying.
So-
That's what I'm saying, there's a whole lot of
It's a
stuff.
whole bunch, right. So, but thank you everybody for coming out tonight. Thank you, Louis, for having me. I appreciate the opportunity.
I have one more question.
Yeah, by all means.